Thank you for joining us tonight. My name is Barry Erickson, and I'm Community Engagement Coordinator at Wheaton Public Library. The ACES, Aging and Caregiving Engagement and Support series, is designed to be a centralized source of information and resources for seniors and caregivers. Tonight, we are proud to bring you this session on legal issues with attorney Yvette Golay of Prairie State Legal Services, a nonprofit legal services organization. They provide free civil legal services for seniors ages 60 and over. Yvette has been with Prairie State Legal Services for 9 years and has worked in the legal aid field for 23 years. She will provide information about powers of attorney, wills, and advance directives such as Living Wills and DNRs. So with that, I will turn the screen over to you, Yvette. Thanks so much for being here tonight.
Thank you so much, Barry. It's my pleasure to be here. Thank you for having me. My name is Yvette. I am one of the staff attorneys at Prairie State Legal Services. I work out of our West Suburban office that serves DuPage County. Next screen, please.
Yeah, let me go ahead and start the screen share.
Perfect. So we're going to advance one more screen when you get a chance. So Prairie State Legal Services is a nonprofit legal services organization, and our mission is really to ensure that folks have equal access to justice and fair treatment under the law. And in doing that, we provide legal advice, representation in court and before administrative hearings, advocacy. We do a lot of outreach, and all of this is really geared for us to be able to serve people to protect basic human needs. Next slide, please. We serve we have 11 offices serving 36 different counties. In my position of the Title III attorney, I provide free legal services to folks over the age of 60 who cannot otherwise afford an attorney and who have a legal issue that's affecting basic human needs. So if you're a senior over the age of 60, there is no income eligibility requirement. You are automatically eligible for our services. And it just so happens that the majority of the seniors that we serve are living on a very fixed and limited income and are living below the federal poverty level. Next slide, please. So as part of our mission, we try to prioritize the most urgent legal matters that affect basic human needs. So examples of cases that we handle include ensuring access to health care. So if you have been denied either community or long-term care Medicaid, or Medicare has refused to provide coverage for a service, we can oftentimes handle those appeals and those issues. Housing, especially now with the fact that the moratorium is over, we're seeing a lot of surge in eviction cases. We actually have 2 attorneys who staff eviction court during the week who are there to speak with tenants who are not otherwise represented and are there to either provide legal advice, to represent the client on the eviction, or to provide assistance with referrals to rental assistance or court-based rental assistance. We also have a lot of clients who have Section 8 or who reside in subsidized housing. And a lot of times they're getting notices that their subsidies are going to be terminated. Maybe there was an issue with a rental calculation. So those are some of the housing issues that we're seeing. We also deal with income maximization. So if you're receiving SSI, Social Security Disability, food stamps, TANF, and you've been receiving a notice that says that your benefits are being reduced or they're being terminated, then we can oftentimes handle those appeals. We also represent clients on guardianships. If someone has a lack of capacity and needs someone to be able to make decisions for them, we'll go into court on those issues. We have a tax clinic that assists clients with IRS disputes. And again, with a lot of my seniors, another issue that I'm seeing a lot of is consumer debt collection issues. So situations where the senior will have either an unpaid credit card bill or a medical bill or an ambulance bill that they haven't been able to pay. Maybe the debt has been sold to a debt collector. Maybe that debt collector has filed something in small claims court. We'll oftentimes get involved and try to advise the client on how to handle that type of a situation. Next slide, please. We also handle, and we're seeing a lot more of financial exploitation issues. concerning our seniors. So the typical type of financial exploitation case that we see are twofold. One is usually an adult child or a relative or someone who is in a position of trust, like a power of attorney or a guardian, and then that person is misappropriating the senior's income or assets for their own purposes. We're seeing a lot of that. But then again, we're also seeing other cases where our seniors are being victimized by scams. I've had clients who are victims of the Jamaican lottery scam, the sweetheart scam. I recently had a client who was a victim of a publisher's clearinghouse scam. So those scams are very well orchestrated, and very targeted at our seniors, and we are seeing those types of cases. Powers of attorney, guardianship, and wills, we're going to be discussing this evening. And then the other type of issue that we're also doing a lot of right now is expungement and sealing. So if the client has a criminal background, and is being denied subsidized housing, is unable to get a job, oftentimes we'll be able to look to see if that criminal record can at least be sealed so that it won't be visible by the housing provider or the potential employer, or if those criminal matters can in fact be expunged. Next slide, please. Different ways for you to apply for our services. You can either call the number that's listed on the screen. We're open Monday through Friday, 8:30 to 5. If you have access to a computer and the internet, you can apply online on a couple of different websites, including our own. IllinoisLegalAid.org is actually another website where you can apply for our services, but they also have a wide array of information about different legal issues, including housing, orders of protection, Social Security. So if you are able to browse the internet, I highly recommend that you go on their website. They do have a lot of information there. We also work with a lot of community partners like Family Shelter Services, DuPage County Senior Services, Metropolitan Legal Services, and all of our community partners that you may have access to have our referral form. So if you're working with a case manager at Senior Services, you want them to send a referral over to us, then they're able to do that. So those are the best ways to really get through to us so that we can do an intake and see what's going on with your legal issue. Next slide, please. So today we're going to be talking about advance directives. So advance directives include powers of attorney for healthcare and property. They include wills, living wills, and then we're going to touch on guardianship and a little bit on financial exploitation. Next slide, please. So I always really encourage my clients to have powers of attorney. As I said, there's two types. There's a power of attorney for healthcare, and then there's a power of attorney for property or finances. And I do know that hospitals and doctors' offices have been asking folks, do you have powers of attorney? And in fact, having a power of attorney can prevent potential legal problems in the future. So to me, they're one of the most important things for my seniors to have. And I think one of the best reasons to have them is because they allow you to keep control over who's going to be making important decisions for you about your finances and your medical care and your treatment. Powers of attorney can be tailored so that they accurately reflect what your wishes are. So for example, in a power of attorney for healthcare, you can decide whether or not you want life-sustaining treatment or not, and whether or not you want organ donation. And powers of attorney really jumpstart conversations between people and their families about, if I'm ever in this situation, this is the decision that I would want to make. Or if I ever have to go to a facility, this is where I would prefer to go to be closer to family. So having those conversations with family really also allows the person who's in charge of your power of attorney to be able to make decisions that are in accordance with your wishes. Powers of attorney will oftentimes mean not having court involvement with your life down the road. And powers of attorney also don't have to last forever. So if you do a power of attorney and down the road at some point you decide that you no longer want it, you can always revoke it. And we're going to touch on that in a little bit. Next slide, please. So the first thing you need to have in order to do a power of attorney is you need to have capacity. So the capacity means to be able to make or communicate decisions about your health care and your treatment and your finances. If you don't have capacity for whatever reason, then you cannot sign a power of attorney or any other legal document. So let's assume that you do have capacity. In this relationship with a power of attorney, you are called the principal, and the person that you're appointing to make these decisions for you is called the agent. And having this power of attorney really does create a special relationship of trust between you and your agent. That agent is required to act and make decisions that are only in accordance with what your wishes are. And if an agent comes across a situation where they don't know what your wishes would have been, then they can only make decisions that are in your best interests only. So having an agent is essentially having somebody step into your shoes. So they're going to be able to handle any sort of medical or financial issue that you would be able to otherwise handle. So your agent will be able to do things like talk to your doctor, request medical records, deal with your mortgage or your property taxes, handle issues with the Department of Human Services that administers Medicaid, or food stamps. The only administrative agency that does not recognize a power of attorney is the Social Security Administration. And it's not clear to me why that is. But even if you have a power of attorney and they're not able to talk to Social Security directly, there are other ways through Social Security consent forms that will allow your power of attorney to have communication with them and address whatever legal issues are going on with your benefits. Next slide, please. So when do they begin? There's different ways that you can have a power of attorney come into effect. The first way is to have it be effective as of the date of signing. Now, on the date of signing, you have capacity. And what will happen with that power of attorney being effective as of the date of signing is that you can then delegate. You can say, I want to make all the decisions regarding my IRS issue, but you as my agent, I want you to handle the sale of my house. So if there's certain issues that you don't feel comfortable dealing with, you're not really sure about, maybe your agent has expertise in this particular area, you can delegate your power of attorney to handle certain issues for you while you still have the capacity to make decisions for yourself. The second way to have a power of attorney become effective is only when a doctor certifies in writing that you no longer have the capacity to make or communicate decisions about your medical care and your finances. And it's only your physician that can determine this. Your agent can't decide this. Nobody else can decide this but your doctor. And that may never happen for some folks, but to have the power of attorney there as a backup will hopefully be a source of comfort in the event that that does occur. And then the third way to have a power of attorney become effective is to select a predetermined date. So maybe you're having a surgery on December 1st, and after the surgery, you're going to be in the hospital for a while, then maybe rehab. You know that you're not going to be able to manage things on your own. You could draft the power of attorney so that it starts as of December 1st, and you could have it end on a specified date if you want to. So it could just be a temporary power of attorney if you need it to be that way. Next slide, please. Generally, powers of attorney, if they are signed, dated, witnessed, and notarized in Illinois, they should be valid in other states. So as long as they're valid in Illinois, you should be able to go to a different state if you decide to relocate, and those powers of attorney should be valid in that other state. There is a prohibition on having two agents at the same time. So you cannot have co-agents. Instead, what you can have is one agent acting at a time. And then after you designate your primary agent, you can have backup or successor agents, which I think is very helpful because in the event that your agent at some point in the future decides, I don't want to do this anymore, or I can't do it anymore, then you're not stuck. Your backup agent will then be able to step up, sign an acceptance form, and they will then be able to act as your primary agent under the power of attorney. In order to be an agent, you need to be of age. So you need to be 18 years of age and also have capacity. Your agent cannot be your attending physician or any other healthcare provider that provides services to you. And then, like I said before, successor agents are definitely a good idea, but they are not required. Next slide, please. So when dealing with the power of attorney for finances or property, the agent has a lot of responsibilities. So the agent is required to act in good faith for your benefit, and they're required to use due care, competence, and diligence. They have to act in your best interests, and they can be held liable for acts of negligence or if they're mishandling your finances. So I recently had a case where my client was on a ventilator and incapacitated in a nursing home. And the case got to us for assistance with Medicaid. And we found out that his sister was his power of attorney for finances. And the short story is that we found out that the sister was in fact collecting some rental income from a property that he had. She was collecting his Social Security disability benefits as well as other benefits that he was receiving at the time. And she was using those benefits to fund her lifestyle. So she was in essence stealing from her brother. And so when we found that out, we went into court, we got a guardianship so that the Office of the Public Guardian for DuPage County was appointed guardian of my client. We got the power of attorney revoked. The sister was ordered to appear in court. She did not. And subsequently, there was a bench warrant for her arrest. She was arrested by the police and brought into court, and she was ordered to reimburse all of the funds that she had stolen from her brother. And the sad part about this was, again, that he was completely incapacitated and had no idea that his sister had done this. So these types of things can happen. And it's important to, when selecting an agent, to make sure that this is someone who's trustworthy. And it may be that maybe your sister would be really well suited to be your agent for medical care. But maybe she wouldn't be so great at being your agent for finances. So it's important to think about, for your agent, what their strengths are, what their weaknesses are, if they're trustworthy or not. Agents are required to keep records of all of the financial activity that's going on and all of the actions that are taken. They're required to, record all of those actions in a ledger or keep, otherwise keep records of them. They have to pay your bills. They can't commingle their money with you, so no joint accounts that has sources of income belonging to the agent and to you. Agents need to be aware of what public benefits you may be eligible to receive. And generally, agents are not personally financially responsible for any of your debts unless they have co-signed on the debt. So if you took out a loan and your agent, who's your sister, co-signed on that loan and you failed to pay, then your sister's going to be responsible for payment of that debt. But other than that, an agent is not personally financially liable for any of your debts. Agents can't do things also that create a conflict of interest. So an agent cannot borrow money from you and use that to pay for their own lifestyle. They can't use their money to pay your bills. No joint bank accounts is something that I see a lot. A lot of my seniors, and it makes perfect sense to me, what they do is they say, well, in the event that I'm at some point not able to pay my bills or make deposits or write checks, I'm going to put my adult child on that account. So that if that time comes, I'm going to have someone on the account who can write my checks for me, make sure that my benefits are deposited, and make sure that all my bills are paid. And that makes perfect sense to me, trying to plan in advance for something that may or may not happen. But the problem with having another person on your bank account is that they're listed on the account as an owner. So even if all of the money in that account is yours and it's just Social Security and nothing else, that money will be deemed to belong to your child if that's the person who's on the bank account. So this can become very problematic in a couple of ways. So the first way is that, let's say you have a bank account, there's $3,000 in it, it's all your Social Security, your adult son is on the bank account as an owner. Your adult son gets sued for not paying a credit card bill. The case goes into small claims court. The debt collector finds out that there's this bank account with your son's name on it. They're not going to wait to find out who the money belongs to or what the source of the account is, what the funds are in the account. They're going to freeze that account until it can be figured out who the money belongs to and what the source of those funds are. So that will create problems for you if you're relying on that Social Security to pay all of your bills. Another problem can arise where, same situation, you have $3,000 in your bank account, it's all Social Security, your son is on the account, your son needs to apply for food stamps. There's a $2,000 asset limit for food stamps. So when your son applies for food stamps, the Department of Human Services is going to want bank statements. So when DHS sees these bank statements, they're going to see there's a $3,000 balance. They're not going to care where the source of the funds are from or who they belong to. As long as the son is on there as an owner, they're going to deem that $3,000 as belonging to the son, and he's going to be denied food stamp benefits. So the better way to do it is to do a power of attorney for finances. And then once that document has been executed, a copy of that should go to the bank. And then you need to ask the bank to put your agent on there as power of attorney only and not as an owner. As power of attorney, they only have the authority to manage the funds in the account. That money is not deemed to belong to them. So that's the difference. But I do see that a lot, and it makes perfect sense to put someone else on your account, but you don't know what potentially could happen down the road if somebody is named as an owner on your account. There are instances where agents can be required to produce records of all of their financial timekeeping that they've done. So you, of course, as the principal in the power of attorney, can request copies of bank statements, credit card receipts, any financial records and documents so that you can see what's going on with your finances. If Adult Protective Services is involved because there is financial exploitation, APS can, of course, request financial records and ledgers. The Office of the State Long-Term Care Ombudsman, whose mission is to protect nursing home residents, the Office of the Inspector General, judges in the circuit court, Office of the Public Guardian, all of these are different agencies and professionals who are in a position where they can demand an accounting, copies of financial records to make sure that the funds are not being mismanaged and that the agent is not acting in a negligent manner. Next slide, please. So talking about a healthcare power of attorney, it's the same idea in that you're appointing an agent who you trust to be able to make decisions about what medical care you're going to get, who you're going to get it from, admission or discharge from a long-term care facility or supportive living facility. Again, your agent is standing in your shoes so they can consent to medical treatment. They can refuse or withdraw medical treatment on your behalf. They can contract for types of services. They can look at your medical records, and they can disclose that those records be given to third parties for whatever reason that might be. Next slide, please. So termination of powers of attorney. So you don't have to have a power of attorney last forever. There's different ways that they can terminate. Generally speaking, powers of attorney do end as of the date of your passing. A power of attorney for healthcare can survive after your passing in order to facilitate coordination of funeral services or cremation or organ donation. But other than that, as soon as you pass, the power of attorney is going to terminate. If you as the client decide that you no longer want your power of attorney, you can revoke it on your own. So you can write a letter to your agent that's dated and signed saying, I no longer wish for you to have authority as my agent under the power of attorney. Your authority is immediately terminated. What I would do is I would make sure that any backup or successor agents have copies of that letter of termination, and also to make sure that any financial institutions like a bank, like DHS, make sure that they have copies of those revocations as well. Next slide, please. So a living will, I often get asked, what is the difference between a power of attorney for healthcare and a living will? So a living will is another type of advance directives, and it applies only when the person has a terminal condition. And the point of a living will is basically to instruct your physician that you do not want any care that prolongs the dying process. And again, it's only when you have a condition that's terminal. So generally speaking, physicians are um, responsible for making sure that they provide life-sustaining treatment to prolong the dying process. So if that is not what your wishes are, and you don't have a power of attorney, you can do a living will that will say that you do not wish to have life-sustaining treatment in the event that you are in a permanent unconscious state. So a living will is also different though from a DNR, a do not resuscitate. A DNR only pertains to CPR. And so it's a document, it's not a legal document, it's a document that you can discuss with your physician. Physicians have these forms that they are required to sign, and you are required to sign. It goes into your medical record. So that is something that is completely different. And then I get clients who ask me, well, what are the differences then between a living will and a power of attorney for healthcare? Because remember that the power of attorney for healthcare also addresses life-sustaining treatment. So the differences are that the living will is a one-page legal document that whose purpose is to say that you do not wish to have any medical care that prolongs the dying process. You don't appoint anyone. It's just a one-page document that you sign. It's witnessed, it's notarized. It becomes part of your medical record. The power of attorney is a much broader document in terms of addressing all different types of medical related treatment and issues. And it does appoint that agent that we talked about. So if you have a power of attorney that says that you do want life-sustaining treatment, but you have a living will that says you don't, if you're in that situation, the power of attorney for healthcare is going to override that living will. So if you have both documents already, you might want to check them to make sure that the instructions are consistent. If you have a living will saying that you don't want life-sustaining treatment, make sure your power of attorney for healthcare also says that. Next slide, please. Okay. So this is what we just discussed about the differences between the living will and the power of attorney for healthcare. Next slide. So if you don't express your wishes, so let's say that you don't have capacity and you cannot sign a power of attorney. What happens then if you are in the hospital? So this is something that happens really frequently. I've seen this many, many times where someone doesn't have capacity, they don't have a power of attorney, maybe they're in an accident, something's happened, they're rushed to the hospital. The doctors don't see a power of attorney in their medical record. What do? Who's going to be making medical decisions? So in the first instance, what doctors will typically do is they'll turn to the Healthcare Surrogacy Act, which basically says in this situation, physicians have to turn to different people in a line of succession to make medical decisions. So the first person that doctors would turn to would be a court-appointed guardian. If there is no court-appointed guardian, then they're going to look to the person's spouse. If there is no spouse, they're going to look to an adult child. And then it keeps going on down a line of succession. But oftentimes, I've found that a lot of times clients don't have family. They're very isolated. They don't really have anybody that they can rely on. And so in that situation, if there is no one, then what the hospital will need to do is file an emergency petition for guardianship in the circuit court, asking that the court appoint a guardian to make decisions about this emergency healthcare treatment that needs to be done. Oftentimes, it will end up being the office of the state guardian. Depending on the person's assets and income, it could be the office of the public guardian. But again, with this guardianship, this is really a last resort because you have no control over who's going to be making decisions about you. You don't know who the office of the state guardian is. You don't know who the office of the public guardian is. So this is really supposed to be limited to folks who really don't have anybody who are able and willing to step up. Next slide, please. Just like with powers of attorney, there's different types of guardianship. There's a guardian of the estate, which is where the guardian handles your finances. Then there's a guardianship of the person, where the person is going to be making decisions about your medical care and your treatment. Guardianships can be temporary. Temporary guardianships normally last about 6 months. They can be brought on an emergency basis as well. And generally, once you've gotten past the temporary guardianship or the emergency basis for the guardianship, if the person does need a guardian long-term, the court will enter a plenary guardian. And all that means is that the guardianship will be in place until at some point, if somebody decides to go to court and challenge that. So guardianships can stay in place for the lifetime of the person. But you can also terminate guardianships. I've had a few clients who had accidents, suffered a brain injury, maybe something happened where their dementia or cognitive impairment escalated to the point where they could no longer have capacity. I've seen situations where clients have really, as a result of rehab and time going by, they've been able to regain decisional capacity, maybe not complete capacity, but at least to regain decisional capacity so that they can now start making decisions for themselves. So I've actually represented several clients on terminations of guardianship for that reason. So it's not something that necessarily has to last for all time. Next slide, please. So wills, we do draft wills. We typically do simple wills, which means maybe the only asset that the senior has is the house or the condo. We don't handle trusts, only because that is a highly specialized area of law, and we just don't have the resources to handle trusts. But we do handle simple wills. People often ask, well, what is a will versus a power of attorney for finances? So a will is basically your instructions as to how you want to have your estate distributed after your passing. A will does not come into effect until after you have passed, whereas the power of attorney for finances terminates upon your passing. So everybody thinks they're supposed to have a will. That's not necessarily true. It's not a requirement. You don't need to have a will. There is no statutory form in Illinois that says this is what your will needs to contain in terms of language. You could write up a will on a piece of paper, and as long as you've signed it, dated it, it's witnessed, it's notarized, it should be acceptable as sufficient evidence of what your intentions were about the distribution of your estate. And I think a lot of clients, when I meet with them, are surprised when I tell them, you don't have to have a will. It's not a requirement. If you pass away without a will in Illinois, there is an intestacy act that also provides people in a line of succession to say who gets what. So if you pass away without a will and you leave a spouse and adult children, your spouse is going to get half of your estate and your children are going to divide the remaining half. If you pass away with only a spouse, that spouse gets everything. If you pass away with only adult children, they get to split everything. So if that's what you want to have happen, then you don't necessarily have to have a will. I have plenty of clients that come in that say, I don't have a house, I don't have a condo, my spouse passed away, I have 2 adult children, there's nothing to fight about, they're not going to fight about anything. Well, then they don't need to necessarily do a will. On the other hand, I do get clients who may not necessarily have any assets, but they have surviving children. So if they pass away, the remaining beneficiaries are going to be their kids. Well, maybe they've been estranged from their kids for some time. Maybe they don't like their kids. Maybe their kids have mishandled their assets. Maybe there's been financial exploitation. They want to disinherit their kids. If that's the case, then I would suggest doing a will. So we've had situations where clients have drafted wills to leave everything to their best friend or their neighbor or their niece or someone who has helped them and provided assistance and been close to them, as opposed to maybe the children that they've been estranged from for 20 years. So if you don't want everything to go to your spouse or to your children, and you want everything to go to someone who's not related to you, I would suggest doing a will so that you can intentionally disinherit your children. In Illinois, you cannot intentionally disinherit your spouse, however. There are also assets that pass outside of a will. So clients will have life insurance policies, retirement accounts, where there are already named beneficiaries. So if you have those types of accounts, you don't need to include them in the will because the funding from those accounts will pass automatically to your named beneficiaries. Wills can also be revoked. I've had people come back after a few years to say, we did a will with you 5 years ago. At the time, we had a house. Now we've downsized. My husband passed away. I need to redo my will. You can either redo a new will that expressly revokes the prior will, or you can write a letter to the executor or your beneficiaries to say, I'm revoking this will and I'm not choosing to do another will. So you can certainly terminate the will. In order for the will to be valid, if you choose to do one, it has to be signed by you in front of two witnesses and a notary. If it's not signed in front of two witnesses and a notary, it will not be valid. And once you pass away, the original will has to be filed with the court. And then I get a lot of questions about probate because I think folks have this idea or understanding that probate is this big drawn out court thing that's really messy and really difficult. And that's not necessarily the case. I think whether or not a case goes through probate depends on what are the assets involved, how big is the estate, are people fighting over, the estate and the house and all the accounts. So just because you have a will and it does get filed with the court after your passing does not necessarily mean that it has to go through probate. And there are different ways of transferring property, liquidating bank accounts, and selling cars that can be done outside of probate. So, for example, if you pass away, you do not own a home or a condo, the rest of your estate is worth under $100,000. A small estate affidavit is a document that can be used by someone. Say your adult child gets a small estate affidavit, they attach a copy of the death certificate. They can use that document to go to your bank, liquidate and close your bank account, sell your car, and distribute the rest of your personal possessions. So there are different ways of distributing your property, which I think goes against the idea of this big drawn out probate case. Next slide, please. I wanted to touch on just briefly as a last topic, financial exploitation, because I've been seeing a big increase in financial exploitation of my seniors. And so, as I mentioned at the very beginning, there's a couple of different kinds of financial exploitation. So, the most common kind, I think, is where you see a perpetrator, someone who's standing in a relationship of trust to the senior, like an adult child, a spouse, a relative, a power of attorney, a guardian. That is the person that's responsible for misappropriating the senior's income, tricking them into signing over title to the house. That's a type of financial exploitation that we're seeing a lot more of. And then the second type of financial exploitation, as I said in the beginning, are those more organized scams. Like there was an IRS scam. There's, of course, the sweetheart scam, which I've had a lot of folks fall victim to, and these scams are very well organized, and they seem to be very real. So it's a big problem. But more along the lines of, the family member perpetrating financial exploitation. I had a case where my client had an accident and he suffered a brain injury, and his son went to court and was appointed guardian of his finances and his medical care. So what turned out happening is that the son moved into my client's house, didn't pay the mortgage, didn't pay the utilities, didn't pay the property taxes. He wiped out my client's bank accounts to pay for his own divorce attorney. Then he wiped out the other bank accounts to pay for his vacation with the new girlfriend. He sold my client's clothes. He got rid of the furniture. He threw away my client's medical assistive devices that he needed. He didn't communicate anything to the facility that my client was in at the time. So very egregious stuff going on here. So when we got this case, what we ended up doing was going into court, and we filed an emergency order of protection. Orders of protection in Illinois are for domestic violence situations between family members, but they also cover harassment, stalking, and exploitation of seniors and folks who are seniors and disabled. So under the Domestic Violence Act, we were able to go into court, get an emergency order of protection that ended up throwing the son out of the house, that ended up cutting off his access to my client's finances and accounts. And he was removed as guardian. We ended up contacting all of the financial institutions and giving them copies of the orders of protection so that the son no longer had access to any of that. And luckily, this was one of those situations where my client was able to rebound and come back and retain some decisional capacity. So that was an example of a situation where we were able to go into court and get this son removed and cut off so that he could no longer financially exploit his father. I have another case now where my client's son was trying to get a house but had bad credit. So he tricked his mother, my client, into signing on title of the deed of the house, and she also signed the mortgage documents because she had pretty good credit. So now my client is not only on the title of this house that she doesn't live in, because the son lives in there with his girlfriend, but now she's on the hook for this mortgage. And getting her removed from the deed to the house and getting her removed from the mortgage is very, very difficult, and could probably most likely cause significant problems for her in the future once she needs to apply for Medicaid or other public benefits, including Social Security, insurance, SSI. So we see these situations a lot. The fact that we're getting more cases, especially during the pandemic, is extremely concerning for us. So we've been working on, what can we do to address these problems? So one option, as with the first example, is we can go into court, we can get guardians removed, we can get powers of attorney removed, we can get agents removed as power of attorney from those documents, we can get accountings, we can request damages. We refer a lot of cases to Adult Protective Services, who are also able to take action on behalf of the senior. I also advise a lot of clients to file police reports, which is very difficult because you're talking about some very tricky and difficult family dynamics. I mean, as a parent, you don't want to call the police on your child, no matter what they've done. Or maybe the senior feels intimidated. What if the perpetrator family member retaliates because you filed a police report? So there's a lot of different dynamics that cause a lot of issues. But in the future, if this senior has to apply for Medicaid and the bank statements show that $10,000 was withdrawn here, or if $20,000 was withdrawn there, that is going to jeopardize the senior's eligibility for Medicaid. So police reports are very important to be able to show that there was exploitation involved, and that it wasn't just the senior trying to get rid of assets to get eligible for Medicaid. We advise a lot of clients about calling the credit bureaus, all three of them, putting freezes and flags on their credit bureau accounts, requesting your annual free credit report so you can look on there and see, are these accounts yours or not? Contacting the credit card companies to have them close accounts if somebody, obtained a credit card in your name, changing a rep pay with Social Security. So there's also different types of lawsuits that can be filed um, under the Power of Attorney Act, under the Guardianship Act. There's a financial exploitation statute as well. So lots of different things that we've been implementing to deal with this increase in financial exploitation for our seniors. And I think the only last thing that I want to get across is that if you or someone that if you suspect that there's a legal issue there, but you're not sure, it's always better to either call us or refer that person to us, because you never know. I always tell folks, if you're getting notices from Social Security that say, oh, your benefits were reduced or your benefits were terminated, if you're getting notices from DHS saying that your SNAP food stamp benefits were lowered, always question these, because Social Security and DHS get it wrong. They get it wrong all the time. I think my favorite example of this was when a client came to see me because his Medicaid had been terminated. And when I looked at the notice that he showed me, it said it was terminated because, according to DHS, he was deceased. Well, they got that wrong. And as a result of that, he went for a period of time without his benefits, which created a problem for him. We were able to get those benefits reinstated and backdated, but at that particular time, it did create issues. So always question the notices that you get, that there could be something like an error that was made by Social Security. And when in doubt, just do not hesitate to call us. These are the types of issues that we're here for. And I think that is all I have. So I'll take it back to you, Barry.
Okay, thank you so much, Yvette. I'm going to go ahead and leave the slides up just in case we want to refer back to them with a couple of the questions that we have. The first question, someone is just commenting that they thought that they saw your office on Roosevelt Road in Wheaton. Has the office moved?
It did. And I was I was not a fan of the move. So we were located on Roosevelt Road in Wheaton, which is very accessible because it's accessible to transportation. The courthouse was pretty close by. And then we ended up merging with one of our other offices. Our Wheaton office merged with our St. Charles office. We are now called the West Suburban office. We were supposed to move last March, but then because of the start of the pandemic, that was backed to May. So since May, we've been in West Chicago, but for some reason, our sign is still up there in our Roosevelt Road office. But yes, we have moved.
Okay, thank you. Someone also asks, can you have one agent for healthcare and a different power of attorney or agent for property or finance? And is that a good idea?
It depends on you. You can absolutely have one person. Your sister is your agent under a power of attorney for healthcare. Maybe she has a medical background and would be better suited to making those decisions, but maybe she's not so great at finances. Maybe your cousin or a neighbor or a friend of yours is an accountant. Maybe you trust them with your finances. So you can have different people. You can have one person for your power of attorney for healthcare, a completely different person for your power of attorney for finances. That's not a problem at all.
Okay, thank you. I'm going to go ahead and stop the screen share at this point. Someone also is asking why, you mentioned pretty early in the presentation that power of attorney, the agent or the adult child cannot communicate with Social Security. You mentioned that that was one of the agencies that they couldn't, and they're just wondering why they might need to.
So it's a weird thing. I don't know what the reason is as to why Social Security does not recognize powers of attorney, but it's annoying. Because a lot of times, Social Security will send out a notice saying, you're on SSI. We think you're not paying rent. We think you're not paying any rent. We're going to lower your SSI benefit. So if your benefits are being affected with Social Security, you need someone to be able to reach Social Security. So since they don't recognize powers of attorney, and you still have capacity, you can either call Social Security with your agent on the phone and verbally say, I give Social Security consent to speak with you, or I give Social Security the authority to speak with this person in the future. Or there's a Social Security consent form that can be signed, giving that person, not under the title of power of attorney, but just as this third independent person, giving them the ability to communicate with Social Security. But it's not a situation like DHS, where you just send the power of attorney and they're immediately going to respond. So you're going to have to deal with Social Security a little bit differently.
Okay, and this is a follow-up question, so let me just make sure that we're clear. Does they're asking, does that agency, which I think they're referring back to the Social Security Administration, do they need to be notified if that parent or senior is declared unable to act on his or her own behalf? And does that affect the benefits?
So yes, so typically what happens is that Social Security will directly deposit the person's benefits into their bank account. But let's say, they go to they go to a facility, a nursing home, and they're not able to manage their finances on their own. They can't manage their benefits. Someone can apply to become representative payee on their behalf, and what that means is you're saying that the Social Security claimant who receives those benefits is not able to manage their finances on their own. Here's a doctor's note that says that they cannot manage their finances on their own. And I want to be able to have the authority to not only collect their Social Security on their behalf, but be able to manage those benefits. So yes. And also by the same token, if somebody regains that decisional capacity, they can terminate that representative pay situation. I do see a lot of, for myself particularly, I see a lot of nursing home clients, and a lot of times facilities will apply to be representative pay so that the benefits go directly to them and they can manage that.
Okay, thank you. Just a reminder to our participants, if you have a question, go ahead and type that in the chat. While we're giving people just another minute or two, Yvette, if we are noticing a neighbor or someone, a friend that we're kind of concerned about that there might be an exploitation situation there, is it your organization that should be contacted first, or what do we do with that type of concern?
In that situation, if it's somebody that's living in the community, I would absolutely call Adult Protective Services. And they're under the umbrella of DuPage County Senior Services. So the number for them is 630-407-6500. I do call them a lot, but they're the first line of defense. They're the ones that are going to go out within a certain period of time, depending on how egregious it sounds. They're going to be the first ones out there to visit the senior, and then they can pull other services in to assist, whether it's senior services, money management program, us, the police. So Adult Protective Services should be the first call. Absolutely. And then also you can call us so that we can also work with Adult Protective Services and see if there's anything legally that we can do to assist.
Okay, thank you. Someone did enter another question. If you have no will and you're single, where, so no spouse, no adult children, where would the assets go upon your passing?
And that's a really good question, because if you look back to the intestacy law, and I haven't looked at it to see just how far down the line it goes, but I think eventually, if there's no one, no cousin, no niece, no nephew, nobody, eventually I think it's going to go back to the state, assuming there aren't creditors. Creditors have 60 days to file a claim. So if those creditors come on board and they file a claim and they say, well, we've got this unpaid bill, whatever's left in the estate's going to pay for it, there may be nothing left. But I think eventually, at the very, very last step, it will just go to the state.
Okay. All right. Well, that does cover all of our questions. So thank you so much, Yvette. We really
My
appreciate all of
pleasure.
your time, and
Thank you for
Prairie State
having me.
Legal Services for providing this for us. Someone did ask in the chat again for that contact information, so I'll say here, this program has been recorded, and we will put it up on the library's YouTube page within about a week. Following tonight's presentation, I will be sending out a whole bunch of contact links as well as that phone number. So that will be coming to you if you registered in an email later tonight. But if you're watching the recording of this program and would like those resources, you can just reach out to me at ce@wheatonlibrary.org. That's CE for community engagement at wheatonlibrary.org. And I'd be happy to send those contact links out to you. But with that, I don't see any other questions. So thank you so much, Yvette. We really appreciate your time. Thank you to all of our attendees. Stay safe and healthy, and we hope to see you again soon. Good night.
Thank you so much for having me. Take care.